Let's see the another questions. So this question was asked in 2014. So the question says, the power of the Supreme Court of India to decide disputes between the center and states falls under its. So the question asks about the disputes between center and states falls under which. It means it won't. The question is, and the question needs to understand the jurisdiction of Supreme Court, right? So we know that there are four types of jurisdictions. One is original jurisdictions. Then the next is appellate jurisdictions. Then the third advisory jurisdictions, and one of the jurisdictions is writ jurisdictions. Yeah. So this original jurisdictions is belong for the federal character. Federal disputes, that is a disputes between the government of India and government of states, disputes between interstate, disputes between state and states, are disputes between the government of India and one or more state on one side versus two or more states on the other side, right? So this is original jurisdictions, which talks about which only deals with related to the federal disputes. Now this original jurisdiction is also an exclusive jurisdictions. It is also an exclusive jurisdictions and a final jurisdictions So original, when we say that an original jurisdictions, it means that the disputes can directly approachable to Supreme Court. So it is an original jurisdictions. So original jurisdictions means a directly approach the Supreme Court or the authority which has an original jurisdictions. When we say an exclusive jurisdiction, so exclusive jurisdiction means that none other than Supreme Court, the court has a jurisdictions to entertain any disputes related to federal jurisdiction. It means the federal disputes only entertained by the Supreme Court. It cannot be entertained or it cannot be heard or resolve the disputes by any other court other than the Supreme Court. So it is an exclusive. And when we say it is a final jurisdiction, it means that decision given by the Supreme Court is binding on the party. So it is original jurisdictions of federal disputes related to federal structure is an original, exclusive, and final of the Supreme Court. Now, when we talk about appellate jurisdiction, so appellate jurisdiction, it means that it's decisions of the lower court. Decisions of the lower court can be appealed to the higher court. So the decisions of the high court can be appealed into the Supreme Court after the certifications of High Court. Advisory, where a government of India took advice, took opinion of the Supreme Court on any matters, on legal matters or pre-constitutional matters. So this is advisory jurisdictions. Writ jurisdictions, which means that restorations of violated fundamental rights through the writs of habeas corpus, mandamus, prohibition, certiorari, and quo warrantos through the 5 of these writs. So this is the jurisdictions of Supreme Court. So the question talks about the jurisdictions which falls under the center and state disputes. So it is a center, and disputes between the center and a state is a disputes related to federal character. So we can say that any disputes arises due to the or there may be a federal disputes comes under original, exclusive, and final jurisdiction. So answer to this question is C, that is original jurisdictions. Now if you see the explanations to these questions, so the article 143 talks about an advisory jurisdictions. So advisory jurisdictions where the President of India can seek the opinion of the Supreme Court on legal or constitutional matters. However, this opinion is not binding, that this jurisdiction does not cover disputes, and this jurisdiction does not cover disputes between center and states. Clear? Next is 132 appellate jurisdictions. So next we can see that it is an appellate jurisdictions. Appellate jurisdictions. So Supreme Court can hear appeals against decision made by the High Court or other lower courts if the High Court certifies under 134A that the case involves a substantial question of law as to the interpretation of its constitutions. So it applies in a case related to civil, criminal, and constitutional matters. So all these type of matter comes under the appellate jurisdictions. The next is original jurisdiction, that is Article 131. So it talks about the Supreme Court has exclusive original jurisdictions in disputes between Government of India and one or more states, the disputes between two or more states, the disputes between Government of India and a state on the one side and other state on the other side, that is a federal dispute arises from the federal characters. So that is on base of Article 131. So disputes between the center and states falls under original jurisdictions. Article 32 talks about the writ jurisdictions. The writ jurisdictions allow individuals to approach the court to enforce fundamental right through the 5 types of writ, that is habeas corpus, mandamus, prohibitions, certioris, and quo warrantos are the 5 types of writs through which the restorations of fundamental right is done by the Supreme Court. And this writ jurisdiction is not cover under original jurisdictions, because original jurisdictions of Supreme Court is only dealing with the disputes with related to federal disputes or federal character. Clear? So let's move to the next questions. Next question was asked in 2014. So let's see the question. The question says the power to increase the number of judges in the Supreme Court of India is vested. So which among the following is empowered by the constitutions to increase the number of judges, right? So as we know that originally the constitution has allowed to the number of judges in Supreme Court, that 7 judges plus 1 Chief Justice of India, which later through the subsequent act this number of judges has been increased to today it is a 33 judges in plus 1 Chief Justice of India. It means the total number of judges into the prescribed strength of the Supreme Court is 34, which include the Chief Justice of India. It means so the number of judges was increased from the initial to the today's time. So which of the authority has been empowered? Does the President of India increase the number of judges? No. The President of India can only have a power to appoint the judges, and that is also on the base of also on the bed of aid and advice of Council of Minister, and they advise on the basis of the recommendations of the names sent by the collegium system, which includes Chief Justice of India plus 4 other judges. So this collegium systems select a name and they send the name to the government, and then on the advice of the Council of Minister, the President appoints them. So President is only appointing authority, right? But it has no power to increase the number of judges. So does Parliament increase the judges? Yes. From Article 124, it has been said that the number of judges to the Supreme Court shall be 7 until Parliament through law increase the number of judges. So it means according to Article 24, it is a Parliament which can increase the number of judges, but that should be done through the law. So Parliament by using the power under 124 has enacted a law, that is on Supreme Court Number of Judges Act 1956, and By amending this act various occasions, the number of judges in the Supreme Court is currently been 34, including Chief Justice of India. Clear? So it is a Parliament who increase the number of judges. It is not a president. So not a president, nor a Chief Justice of India, nor Law Commissioner who can increase the number of judges. Clear? Let's see the explanation to this. So Article 124 talks that establishment and constitutions of Supreme Court. It says that there shall be a Supreme Court of India consisting of Chief Justice of India until Parliament by law prescribes a large number of not more than 7 other judges. So originally 124 talks about that originally there will be a 7 other judges plus Chief Justice. Till that time, Parliament by making a law makes a increase in the number or prescribed a large number. Clear? So the Constitution originally provided a Chief Justice of India and 7 other judges in the Supreme Court. However, the Parliament has the authority to change this number by enacting a law as its legislative power. So using this power under Article 124, the Parliament has increased the strength of Supreme Court through various amendments to the Supreme Court Number of Judges Act 1956. So through this act, the Parliament empowered itself to, or the constitutions empowered the Parliament to make law. The Constitution has made law, the Parliament has made law, and through this law, the Parliament increases the number of judges. So it is Parliament who has empowered by the constitutions through law to increase the number of judges. Clear? Let's move to the next question. Next question was asked in 2012. So question says, which one of the following are included in the original jurisdiction of the Supreme Court? So now we come to know that original jurisdictions means it is a disputes arises due to in the federal character. So the federal character disputes only can be covered into the original jurisdiction. So federal character disputes mean that if maybe a dispute between government of India and state, or between state and state, or government of India and state on one hand plus other state on the other hand. So this is a disputes. So let's analyze the 4 of the given statement. So first says, disputes between government of India and one or more states. Yes, it is covered under the original jurisdictions. So 1 and A and C is our answer. So B and D cannot be our answer. Now if you analyze carefully the options, so if you see that 1 is combined either with the 2 or with the 4. So and 3, and there is no options 1 is combined have a combination with 3. It means the third is automatically incorrect according to the given options. So when you analyze this, that 1 is going with the 2 or either 4, so it means that if we just analyze the second options and if we try to find whether it is true, correct or incorrect, so we are without going to the option 4, we can mark our answer. Yes or no, right? But we will see all the options. So let's first analyze the second statement, whether it is true or not. So second says, a dispute regarding elections to either House of Parliament or that of a legislature of state. So it means that deciding the election petitions. So this has been, though the Supreme Court has election petitions, jurisdictions, yes it has, but it is not related to the member of Parliament or legislature of state. This the second statement, which says that the disputes with respect to elections of member of Parliament and state legislature belongs to the original jurisdiction of High Court. It is not an original jurisdiction of Supreme Court. So on this line we can say it is incorrect, right? Second, the logic on which also we can say that second statement is incorrect is that though the Supreme Court has decides the election disputes, but that is election disputes of president and vice president. It does not decide the election disputes of MPs or MLA. It only the Supreme Court can decide the election disputes with respect to president and vice president. But this jurisdictions of election dispute is not under the original jurisdictions, not under original jurisdiction of Supreme Court. So on this logic, on the two logic, we can say the second statement is incorrect. Now, if the second is incorrect and first is correct, so we can say that through the logic eliminations method, which I use referrally as a logic. So 1 and 4 is a correct. So answer we can easily mark without referring all the 4 statements, just referring only to the 2 statements. We can easily arrive to our answer, that is 1 and 4 is a correct answer. But in this discussions, we are going to analyze all the 3 options. So why the third is incorrect, if you see? So it says that a disputes between Government of India and Union Territory falls under original jurisdictions. No, it not. Why? Because Union Territories are controlled by the Government of India. So there is no question of disputes arising under its own control. So UTs are either directly or indirectly are controlled. The UTs who are having legislature is also controlled by the Government of India through the LGs, and some of the departments were kept under this, right? Appointment by the president is done in the UTs, whereas the UTs does not have an legislature, so does not have legislature, so they are been directly under the control of Government of India or a union government. So this cannot be the answer, so C is not. And why the fourth is answer? Because it says disputes between 2 or more states. Yes, it is one of the features. So answer to this is 1 and 4. Now if we see analyze the reason for this answer or logic behind this, so it says that Article 131, which talks about original jurisdiction, and it says that Supreme Court has exclusive original jurisdiction in disputes between Government of India and 1 or more state, that is 1, 2 or more states, that is 4, and the third says the Government of India and a state on one side and other states on other side. So these are the original disputes, that is 1 and 4. Now related to election disputes, so it says that it has been provided that no election to either House of Parliament or state legislature shall be called in question except by an election petitions presented to a High Court. So the deciding of election disputes comes under the original jurisdiction of High Court, though the party may challenge the decision of the High Court to Supreme Court, but that comes under appellate jurisdictions, not under the original jurisdictions. So a right to appeal to the Supreme Court from others order of the High Court is available to aggrieved party, and this makes this as an comes under appellate jurisdictions. Clear? Now UTs are administered by the union government itself, so such dispute does not arise in this context. Yes, it is true, the UTs are under this administrations of government. Clear? So answer to this question is 1 and 4. Now if we move to the next questions, so the next question asked in 2012. Now it says that what is the provisions to safeguard the autonomy of Supreme Court of India? So it want to ask the autonomy through the Constitution of India has provided to safeguard the Supreme Court autonomy, means independent nature of character of Supreme Court, and we know that Indian judiciary is independent plus integrated judiciary. So we have an independent judiciary, the character of which we have taken from the USA. We have an integrated judiciary, the character which we have taken from the UK constitutions. So integrated judiciary means that there is no division of power between the judiciaries, like unlike the 7th schedule, there is no such schedule which divide the power between the judiciary. This is integrated judiciary. So we have an hierarchy in a judiciary, right? Supreme Court, then High Court, and then subordinate court, which comes under the control of an higher court. The lower court is under the control of higher court, or subordinate court is under the control of High Court. Clear? So how the provisions of the constitutions make it an independent nature of a Supreme Court. So let's analyze all the four given statement. Clear? So first is that while appointing the Supreme Court judges, the President of India has to consult the Chief Justice of India. Yes, it is true. It is true, as we know, that the appointing authority is President of India. Yes, on the advice of Council of Minister. But the consultations with respect to while appointing a Chief Justice of India, the President has to consult other judges of the Supreme Court, and while appointing other judges other than the Supreme Court, other than the Chief Justice of India, the Chief Justice of India consultation is must. That means they have to consult. In this context, we can say the first is true, and this consultation is been made through the, which says that through the collegium systems, which consists Chief Justice of India plus four other judges. I get your point. So on this basis, the first is true. So we need to find the correct answer. So if the first is true, so it means either our answer will be A or D, right? So B and C cannot be the answer. And if you see the A and D, that common is A, 1 and 3, right? So if the second is incorrect, then answer would be B, A. If second is correct, then answer would be D. So through only analyzing the second statement, through this we can easily derive, we can come to our answer, mark our answer, and we can save our time. So let's move to the second options. The second options of this second statement, not option, but second statement talks about, let me clear all this. So second is the Supreme Court judges can be removed by the Chief Justice of India only. No, this is incorrect. So how the Supreme Court of Judges are removed? So they are removed by President of India. President on the motion passed by Parliament. Clear? So the President is empowered by the Constitution to remove the judges of Supreme Court, but not by its own, but only when the Parliament passes that motions in that respect. So if the Parliament does not pass any such motions with respect to the removal of judges, the President cannot remove. So the removal of judges comes under it only by President only by the motion passed by Parliament. So second is incorrect, and if second is incorrect, it means the answer to this question is A, that is 1 and 3 is correct answer. Now analyze why the third is correct and the fourth is incorrect. So third says the salaries of the judges are charged on the Consolidated Fund of India, to which legislature does not have to vote. Clear? Does it have? Yes, it is true. And as we know that the budget of the government of India, under the budget, the expenditure contains two part. So under budget, the expenditure part of the government, contain two parts. One, the expenditure charged on Consolidated Fund of India, and one is the expenditure charge made on Consolidated Fund of India. So this charge on Consolidated Fund of India are those charge which only can be debated, not to voted by Parliament. And this charge made on Consolidated Fund of India is an expenditure on which the Parliament discuss plus vote on this. So in this, the charge made on Consolidated Fund of India, the Parliament can deny this expenditure, but Parliament cannot deny the charge made on the Consolidated Fund of India. It includes the salaries of President, Vice President, pensions and salaries of Supreme Court judges, pensions of High Court judges, so pensions of government staff, and all this comes all are under the charge on Consolidated Fund of India. It means it can only be discussed by the Parliament. It cannot be voted by the Parliament, and through this it means, and through this mechanism it says that the salaries and allowances of the judges of Supreme Court cannot be altered during their during the office times, and this make them an independent, fearless, and to make an unbiased decision. So this, on this logic, the third is correct. Now why the fourth is incorrect, if you see? So the all appointments of the officers and staff of the Supreme Courts of India are made by the government. No, they are not made by the government. They are made by the Chief Justice. So Chief Justice of India is sole authority, or you can say that having a power to appoint all the staff agencies in the Chief Justice, Supreme Court office, Supreme Court premises. So all the Supreme Court officers and staffs are appointed by the Chief Justice, not by the government. So on this line we can say that fourth is incorrect statement. Clear? Now if you see to the explanation to this, so says that according to Article 124 Clause 2 of the Constitution, the President of India appoints the judges of Supreme Court after consulting the Chief Justice of India and other senior judges as deemed necessary. The collegium systems evolved through the Supreme Court judges also play a role in judicial appointment, enhancing autonomy. So on this logic, the first is correct. Now according to Article 124 Clause 4, a judge of a Supreme Court shall not be removed from his office except by an order of President. It means only by the order of President, passed, and when it can pass, after an address by each House of Parliament supported by a majority of two total membership of the House, and by majority of not less than 2/3 of the members of the House present and voting. It means the House, each House should pass separately with the special majority, has been presented to the President in same session for the such removal on ground of proved misbehavior and incapacity. So process is also mentioned in the constitutions, and ground is also mentioned in the constitutions. So they are being removed not by the Chief Justice but rather by the President. So on this logic, the second is incorrect. The salaries and allowances of the judges of a Supreme Court are charged on Consolidated Fund of India as per the Article 112 and Article 226 of the Constitution. It means they can only be discussed by the legislature, cannot be voted on it. Okay. So on this, the third is correct. As per Article 146, the Chief Justice of India has exclusive authority over the appointment of officers and staff of the Supreme Court. So only the Chief Justice of India can appoint the staff and officers of the Supreme Court. So on this also it is incorrect. So this is an answer. After this we can say that only 1 and 3 is a correct answer to this question. Clear? So this is the last question of this series of judiciary. So I hope that this will help you again to prepare in a very short time the judiciary questions. We have tried to analyze in detail of the each of this options wise or statement wise. So I hope this will help you to prepare better and to score better in examinations. So all the best. And I also request you all, to those who are watching the YouTube this series, so please make some comment how you like the videos, and also subscribe to the channel, because analysis shows that the videos are shown more by the unsubscribed, those who does not subscribe. So those who only come and see the video, so please subscribe, that you can get a notifications when we upload the videos, and also ask your friends to do the same. Thank you.